on these questions about WhatsApp messages and the legal evidentiary value of a WhatsApp message, which isn't from Deepika's phone just at this moment, but it's only logical that when Deepika Padukone comes before the NCB, they're likely to say phone though. They want to go through her messages. If she's cleaned them out, they'll put forensic experts on the act and try and retrieve messages that may have been deleted. If those messages are found, what is the evidentiary value of those messages which are on Deepika Padukone's phone?
Rahul, I'll just try and first explain the technology and what it means as far as the data bit is concerned. So there are two aspects to this. One is data at rest or data in transit. Now the police is legally equipped to deal with both under various circumstances. Data in transit is if I am sending a message from my WhatsApp to your WhatsApp and this data is traveling, then under certain powers, especially under Telegraph Act and the Information Technology Act, the police can access it. 10 agencies have been notified by the Government of India. State police is one of those 10 agencies, which can then access that data and intercept it legally. It's called legal interception or legal monitoring. In this case, happens to be a case of data at rest, which is data when it is kept within a device or in a cloud, somebody can access it. Now, this is where it gets into tricky legal territory. According to Article 20, Subclause 3 of the Indian Constitution, you cannot self-incriminate. And there is an 11-judge bench of the Supreme Court which has ruled that yes, this is a valid thing, and you cannot be forced to give up your password or passkey of your device when the police ask for it. Now, if you have seen what has happened in America, for example, the FBI versus the Apple case, where Apple refused to share the passkey of a device which they wanted to use for incriminating someone, and Apple said, we will not share it. So they took it to an Israeli hacker who used one vulnerability in the Apple encryption code and then took that material. So that's one aspect of it. In this case, it's very interesting that most probably Deepika or anybody else's chat has been taken from some other accused person's phone because the police have accessed it. Now we'll have to check under what circumstances the police actually took that. Now when you are using WhatsApp, you asked a very interesting question. It is end-to-end encryption. Now end-to-end encryption, so far WhatsApp cannot be compromised, but that applies to when data is at rest. If that WhatsApp chat is lying on your phone, then yes, they will need a certain access, which is the passkey to your phone or your cloud to access that data. Now, many people don't do a backup to the cloud, so that will be difficult to get. But if the chat is still on your phone, and if you have still deleted it, under forensics, using forensics tools, you can still access that data because many times devices in their hard drive retain that data.
Okay, so these are important points that you're making. One, that if the agencies can find WhatsApp messages on your phone, even if they are deleted, you can't be forced to self-incriminate. So apart from that one message which the agencies already have, it's not as if, and I want to bring in Karuna Nundy on this, agencies can force, can they in your view, Deepika Padukone, give us your phone, give us your passport, give us your password, we'll try and pry into your phone, your deleted messages, try and see whom you've been messaging, who you've been asking for drugs, hash, weed, whatever else it is that she may or may not have been consuming. You've got Saikat making the point that the agencies can't force someone to do that. However, we've already seen in the case of Jaya Saha and Riya Chakrabarti, the agencies have the WhatsApp messages, even those that had been deleted, and are using those as evidence. How compelling is that evidence, Karuna?
There isn't the fruit of the poisonous tree doctrine in this country, Rahul, which I think there should be, because I think it's completely in line with the 9-judge bench on privacy. Now, what is that doctrine? It means that if you have got evidence in a manner that is unlawful, then you can't use it. That's a doctrine that exists in the New York State and a large number of other jurisdictions.
How do you decide that it's been accessed in an unlawful fashion?
If it's illegal, if it's been accessed in an illegal way, so it has to have violated some law in the way that you've accessed it, right?
No, but let's deal with the case that we have at hand, Karuna, because you've got Jaya Saha and Riya Chakrabarti who are accused in the case. They've got FIRs against them. The NCB is probing those FIRs, and they've said, okay, show us your phone, we want to see who you've been chatting to, and they've now dug those messages out, even though they've been deleted, and are wanting to use those as evidence. Is that kosher or not?
Section 69 of the IIT Act is a big problem. What it says is that agencies have the right to de-encrypt particular messages. Now, what Saikat was quite rightly pointing to was he was pointing to the provision in the Telegraph Act, which was the earlier provision that covered surveillance. And that went to the Supreme Court, and that was challenged in the Supreme Court by the People's Union of Civil Liberties. And unfortunately, the Supreme Court came out with a judgment that merely said that an in-house mechanism approving such surveillance would be sufficient